Testimony from Jason Autry. What we know about Jason Autry is that he arrived at, or he went to Zachary Adams under the impression that they were going to brew some meth or something to that effect. But once he arrived, he testified that there he found out that they were actually going to be discarding of the body of Holly Bobo. We have with us today Deborah Blum, who is our Law News trial analyst. Deborah, thank you so much for being with us here today.
I'm so excited to be back.
I know, this case is, it's an unfortunate incident, of course. We never want to take away from that fact. But this case has been amazing. It's an amazing case to watch. I believe that both sides are doing a pretty great job, but we have some amazing testimony from the witnesses so far. So we just heard from Jason Autry, and we know that he's providing testimony in exchange for some leniency, and we've seen that in the past, whether it's for immunity or whether it's for just taking off some years on the ultimate deal that they may have made with the prosecution. Is this something that you find often as a defense attorney? And tell us a little bit about that.
Well, we have a saying as defense attorneys that snitches get stitches. But, unfortunately, sometimes your client has no choice and they're backed up against the wall, and they have nothing else to do but to cooperate.
Right.
So a lot of times the prosecution or the U.S. government gets information from those who are the subject of a crime, target of a crime, or the accused themselves.
Right.
So the prosecution wants to be able to go after and pin the main person who's guilty, who they believe is guilty of this crime, and for them to do so, they have to make a deal with the devil. So that is what's going on here. I mean, we've heard Autry testify that he went and he injected himself with something before he discarded the body.
Right.
So to me, that's already a problem.
Right.
Making this deal as the prosecution with the devil, it just opens up a lot of poking holes by the defense. And I also want to say that you oftentimes have people that get themselves into situations of criminality who really weren't looking for it, who made a really big mistake and they just can't get themselves out.
Right.
And that seems like it's what happened to, if his version of events is true.
Right.
Because there's a lot of doubt, I believe, in this case. But if Autry's version of events is true, he might just be someone that showed up to buy drugs and really just got incredibly unlucky that this is what he got involved in. And it's so horrific that this young woman died.
It absolutely is. So what are you thinking about the fact that he came into it after the fact? Explain to our viewers a little bit about an accessory after the fact. What is he looking at in terms of a deal, or in terms of is it possible that he could get the same amount of time as Zachary Adams? Tell us a little bit more about that.
This is actually a really great question, because here we don't know what his immunity is,
right.
Or at least I haven't been able to find it, and I don't believe that others at the Law News Network are 100% sure what he is guaranteed to get. I mean, of course, his testimony needs to be credible, so the prosecution has to feel that he is testifying credibly, and I don't know what barometer they use to do that with somebody that has a drug addiction like this person does.
Right.
And, drug addiction happens, and I'm certainly not pointing a finger, but I think that we just don't know what he is going to get. And to me, that's incredibly risky, because he could get, as you said, just as much time as Adams.
Right.
An accessory means somebody that was there, somebody that was involved, and just their sheer presence alone is enough to find them guilty.
Right.
Of possibly the top count.
And that is an unfortunate circumstance. However, he delivered some really gruesome testimony as to the fact that Holly may have actually been alive at the time that they were going to discard of her body. Now, her being alive and him stating that, oh my gosh, this effing B is still alive. I don't want to, deliver the exact words on the network, but this effing B is still alive, so that we know that during this time, Holly is still alive when she's wrapped up in this material, and that they're discarding. I mean, imagine all of the things that she had already been through. She had already been allegedly raped, and now she's wrapped up, and then you hear this muffled sound underneath, I believe it was a carpet or whatever, a rug, whatever it was that she was wrapped up in. And then we know that Holly is ultimately shot in the head. So this is going back to the prosecution's allegations that she suffered a cruel death. Tell us some more about that.
Well, I believe this is a state where they have capital punishment,
Yes.
and that's something that would be considered during the punishment phase of this. You know, this was heinous. And what I take issue with, though, is the fact that Autry was present during this incredibly important time period where he could have saved a life. He could have tackled his friend and said, no, don't shoot, don't do anything, let's save her. But he elected not to do that. So to me, listening to him as a juror, I would have a hard time believing what he said or feeling that he's a decent human being whose word we could take at face value, because why didn't he stop his friend from shooting Holly Bobo? The other excuse he could offer is, oh, I was under the influence of drugs.
Right, I did want to talk to you about that. Go ahead, keep going.
You know, but that again opens up this concept of doubt, which is what the defense has to argue here, is there is reasonable doubt. You're hearing someone who admits to you he didn't try to save a life.
Right.
You know, I can't imagine the scenario. It's so gruesome.
Yeah, no, absolutely. So you brought up a great fact, and the fact that he did testify that he was under a lot of dope during this time. So how do you think that makes his testimony so reliable? Because we know when individuals are under the influence, there are some things that they recall, there are some things that they do not recall. But we know that his testimony is instrumental to the prosecution's case here. So how is the jury able to take what he says as truth?
Well, they're going to try to bolster his testimony. They're going to try to use Zachary Adams' brother's statement, a confession that he was there, that he witnessed Holly Bobo in the room with his brother. But the defense has to argue that that was a coerced confession, that it's not real, that he really would not have said that but for his fear of being hurt by the police or whatever they're going to come up with, whatever they're going to say. So, you know, again, I don't know that based on the players here who are under the influence of drugs, who have severe addiction issues, how is that enough?
Right. Well, you know, let's think about it this way. We know that that defense, and as the criminal defense attorney, you know, we're looking for physical evidence. Was our client there? Can you have anything to tie our client to this incident? But we know that the prosecution's case here is purely circumstantial. We don't have anything except for the gun that they allegedly found this year, but still has not been able to be tied to Holly Bobo, excuse me, or even where she was found. But I think that the prosecution here is doing a great job in leaving breadcrumbs here for the jury. The fact that we have the cell phone towers from the testimony over the weekend, that the pings are essentially bringing both Holly Bobo and the defendants here in this case in the same general area. But we also have the fact that Jason Autry is providing testimony that is similar to the confession that was provided by Adams here. So what I want to talk about is credibility. We know that it's up to the jurors in this case to determine whether or not the testimony provided by the witnesses is in fact credible. It's the jury's job to do that. But when we're having consistent testimony, do you think that the fact that Adams here, who allegedly may either plead the fifth or state that, you know, we know that he's stating that his testimony was coerced by the investigators in this case, do you think that it's going to have a role to play in this trial?
You know, I think that this case is all over the place because, as you said, there is no direct evidence, and people like to have direct evidence. I want to touch upon the fact that the judge is allowing in this gun. I think that's extremely prejudicial and unfair. That gun cannot be tested. It's too rusty, so we can't do ballistics testing on it. We don't know that it was the gun used during the commission of this crime. So I don't know why that's being shown to the jury, being published to them. That's just completely unfair. If you can link the gun to the crime, absolutely the jury gets to see it if the chain of evidence is established appropriately. But how is there a chain of evidence? We don't know that this gun was used, and it was found years later, and it's not linked to the crime. But, you know, again, like what you were saying is, in a circumstantial evidence, you rely on the witnesses to put together a story.
Right.
And I do have to say, even though I'm a defense attorney, that the prosecution is weaving this story.
They are.
And, cell phone pings really are making my job and everyone else's job as a defense attorney a lot harder because it goes both ways. Let's say your client doesn't have their cell phone when they allegedly commit this crime, then the prosecutor is going to say, well, that shows that they were going to go commit a crime because they shut it off.
Right.
But then you have your people who leave it on and they're placed around the scene of the crime. Fortunately for the defense in this matter, this is a small town. It's likely these people were all going to be within the same cell phone tower.
Right.
It's not like New York City where one person could be in Harlem, one person could be in the Lower East Side, and one in Brooklyn.
Right.
So I think that is easily argued, look, this is a small town, we're all pinging off of that same cell phone tower.
That's a great point. That's a great point.
The defense has a hard time here with the fact that the witnesses are adding to the same consistent story that these individuals were the ones that perpetrated this horrible criminal act.
But, okay, in regards to this gun, as a criminal defense attorney, don't you think that may be a little gem for you, even though it was, and we'll talk some more about that with the judge admitting this gun into, or allowing this gun to be admitted into evidence. The fact that this gun was found nearly 7 years later after this incident occurred, and it has nothing that's tying the, the defendant to this case. Explain, as a criminal defense attorney, how would you provide that to your advantage? Because I'm thinking, when I'm putting my criminal defense hat on here, I'm thinking, well, you don't have anything tying my client to this case, and it just makes the prosecution seem a little desperate. You're bringing in this gun that's been found 7 years later. We don't know if it's really the gun that was used. We don't have anything tying, Zachary to this to this case. We don't know that it was in fact the gun that was used to in fact kill Holly Bobo. So what can we ultimately say about this gun? In my opinion, it's nothing.
I would say that this is a classic smoke and mirrors argument.
Right.
What do we have here? We have people giving you a lot of hearsay. A lot of people saying, well, Adams told me this, or that one said that, and no one witnessed anything directly other than someone who's going to recant their testimony, who's going to say, look, I was forced into giving a confession to the police. It's not true. They told me what I had to say. Oftentimes, I encounter this with my clients where they'll come to me and they'll say, look, I made that confession because the police told me that if I didn't do it, it was going to be a million times worse, and that the charges against me would be trumped up. So they feel they have no choice but to do what the police wants them to do. And they'll give these confessions while being videotaped, but we don't know what happens before the videotape is rolling. That's when the police force them into saying what they want them to say. So you argue that. Then you argue that Autry was so under the influence, he had shot himself up, and he's another one that's looking to get himself out of something. This is somebody whose mind doesn't work in the same way as a reasonable person's because it's really under the influence of perpetual and habitual drug use. And how can we find that person credible? Again, what is he saying? That I saw Adams shoot Holly Bobo? Like, is that really true? Is that really what happens?
Right. Well, we do have testimony from a doctor that testified that essentially the fracture that was found in the skull, I believe there was one entrance wound and one exit wound, was the gun. So we do have something, I guess, that's, like you said, that's weaving in this circumstantial evidence. So we do have that a little bit. But what I really want to talk to you right now about is this gun. The gun that was admitted by this judge. Do you think that if for some reason the jury finds that Zachary is in fact guilty, and of course we go through the death penalty phase of this trial, and he's in fact convicted, do you think that he has some cause for appeal with this gun being admitted?
Appeals are another chance of possibly setting the person free or giving them a new trial, I don't know that that's enough. I do think that it's extremely, as I said before, extremely prejudicial, extremely unfair, and it gives the jury something to see, and they're going to think that was the gun used during the commission of the crime. Even if you tell the jury over and over again, and at the end they'll be charged, or at least I assume the defense here is going to make an application that the jury be told this was not the gun used during the commission of the crime, or you have to question that this was the gun used during the commission of the crime. I haven't been following it closely enough to know if the type of gun that it is the same type of gun wound that entered and exited Holly Bobo. I don't know. So there's going to be a curative instruction to the jury. But yes, on appeal, this is certainly something that you would bring up, because that is kind of like giving direct evidence that doesn't exist.
Right. Okay, so let's bring it back to when we first started, or when the prosecution and the defense first started. We're starting with opening statements. And I would like to say, I don't know if you were able to watch the opening statements, but it started last Monday. And I would like to say that the prosecution here in this case mainly dealt with emotions. He kept repeating certain things in this case, the prosecutor who provided the opening statement, really tying at the emotions of the jury, whereas in the alternative, the defense concentrated on facts. The fact that there's no DNA evidence linking Zachary to this crime. There are no hair fibers. There was nothing found in the home, in his home, when it was I guess when it was investigated, or when it was looked through, approximately 4 years after the incident occurred. So what do you think about that? In my opinion, when we have the prosecution, and as a former prosecutor, when I'm using the emotions of the jury, that means like I don't have much. And when the defense is saying that, and when the defense is able to, tie in facts of what me as a prosecution or what the state does not have, I'm a little bit in trouble here. What are you thinking?
Well, I've seen the prosecution do all kinds of tricks, no offense.
No, none taken.
I wouldn't say that here this is necessarily a trick, though.
Okay.
I've had this conversation with people that aren't born in the U.S., who come from a system of justice where things are going to be allowed in that we will not have allowed in, or typically allowed in at trial.
Right.
Sometimes people think, just because you don't have a smoking gun, just because you don't have DNA evidence, that does not mean that these people did not commit this crime.
Very true. I mean, we know that they were able to find him. They looked through the home 4 years after the incident occurred. So there's really not much that they would have necessarily found. And I'm sorry to interrupt you. Go ahead.
No, exactly. That's what the prosecution is going for here.
Right.
They're saying, look, I understand that we don't have direct evidence, but what we do have is X, Y, Z, and those are enough for you to convict.
Right.
Beyond a reasonable doubt doesn't mean that you have to have a million shreds of doubt. They just have to prove that this occurred, and beyond a reasonable doubt. And to me, I'm still not 100% certain what that standard is. As a defense attorney, I try to make it sound like a huge burden, which it is. It is the highest burden that the prosecution could have, or that anyone would have in a trial. But I think that using emotions is just going to, sometimes we have common sense, and that's what I'm asking you to do here, is use your perspective as a person based on your daily experience, and does this add up? Is this enough to prove that these people committed this atrocious, or this individual, Zachary Adams, committed this heinous crime, and, versus fact? Because when you have fact equals a lot of doubt, so that's why the defense is using that.
Right. Let's talk about the fact that Shane Austin committed suicide. What do you think about that?
I actually, on the way over here, was looking over the notes that I have on this, and that, popped up, and I thought to myself, that's a little bit problematic. I don't know if the jury is aware that he committed suicide. Again, I wish I was paying more detailed attention to this.
But you have work to do.
I do have to service my clients and go to court like you do. So, but I'm curious what the jury is going to learn about that, because I would think that's another thing, like playing to the jury's emotions. Why did he commit suicide?
Right.
I mean, I've visited my clients so many times in jail, and it's a terrible place to be.
Right.
So I certainly have, I feel terribly for people that are imprisoned. Yes, they committed a bad crime. It's just the standard of life there is so terribly low.
Right.
So if this does come to the jurors' attention, the defense could argue, you know, you're behind bars, somebody else has complete control over your life. It's a horrible place to be. If you suffer from depression, you could possibly commit suicide. That makes a lot of sense. It doesn't mean that he committed suicide just because he is guilty of this crime, guilty of his participation in this crime. But to the jury, you know, why else would he commit suicide?
Yeah, you're right. Well, I think that we have the jury coming in, so I think we might be tuning in to. Am I correct? Oh, yeah, we're actually going to be tuning in. So let's stay tuned to